Oh, hello, the people have already joined. We're just waiting for a couple more people to join and then we'll get going. Thanks for joining so far. Well, thank you very much, everybody, for joining us. We've now got a good number of people on the line. It's great to see so many people and friends joining in and listening into this in this very strange situation we will find ourselves in. And I'm sure we'll be all doing a load more of these. Anyway, so thank you for joining us, particularly if, like me, you're in a place where the weather's absolutely beautiful. I'm sure you've got better things to do than this. The subject of today's webinar is an international review across a number of countries in Europe as to how preliminary injunction procedure has adapted to the COVID-19 crisis. Are preliminary injunctions still available? When might things change? And should you still be thinking about them? And I'm pleased to say that we've got quite a few rights owners on the line, and obviously the preliminary injunction or the threat of a preliminary injunction is of great importance in your suite of solutions when dealing with an infringer. And if it turns out that during COVID-19 you can't get preliminary injunctions, then what do you do to ensure that people don't go too far and take too much advantage of your rights? So, this is Marc Owen. I'm the head of the IP and Media Group, Wessing in London. I'm joined by colleagues from France, Marc Schuler, from Belgium, Keup, from Austria, Marc Prohaska, and from Germany, Sebastian Fischoeder. And we are going to give you a review not only of those 5 countries, but of several more in terms of what's happening at the moment. And I should stress, although we are now 5 or 6 weeks into this crisis, things are still evolving. Different courts are coming up with different approaches, and as technology settles down, technology use expands, I think many courts are going back, not quite to business as usual, but along those lines. So in terms of what we're going to talk about, we're all going to try to address a similar list of questions in respect of each of our countries about what processes are available now, what happens about things like delay, how long it takes to get an injunction, what you do about hearings and impacts on evidence, and then service of the order. But please, if you have other questions or you feel that your particular question hasn't quite been answered, please do use the Q&A tab, which hopefully is visible to you, to ask questions, and those should pop up in front of us and we can answer them as we go. Or if you want to ask questions afterwards, we're all only too happy to answer those and to give you a combined response if that's appropriate. As I say, it's a very movable feast, and this represents really a snapshot of practices today. So starting with the UK, and down the left, you'll see there are 6 questions which we're essentially answering or trying to answer in respect of all the different jurisdictions. The first one is, are preliminary injunctions likely to be granted in the UK during the COVID-19 crisis? And the answer to that is yes, they are, and they are still being granted now. The court is in theory operating exactly the same way as normal. There are just as many judges working, there are just as many courts available, but none of the courts are open. So you cannot go to the court and have a hearing, but the normal way the English court deals with many of its processes, including preliminary injunctions, is carrying on exactly the same way, but in a digital form. So, for example, the United Kingdom, or the English court rather, if you have an urgent order, there is a judge each day who runs a thing called the Interim Applications Court, and you can just rock up to that court with your papers and say, I want an urgent order in respect to this. And there'll be lots of other people doing the same thing, and the judge will then decide which order those things are heard in and who hears them. Sometimes they're farmed off to other judges. That process is carrying on in the same way, but it's all being done by digital. You email the judge, you say this is what they want, and then you get an answer saying, well, this is what you have to do, this is who will hear your case, etc. Things are carrying on as normal. Some of the procedural aspects have changed a bit. Like I say, it's all done digitally, and some of the timings may stretch out a little bit because some steps are harder, and everyone recognises that. But the court regards it as important to carrying on being able to deal with urgent requests from claimants to deal with infringements. And if you think about how long this may last, it doesn't really seem feasible, although I know that may vary country by country, to not have any of these sorts of orders being considered and to store them all up for however many months in the future life returns to something approaching normal. There'll be a huge backlog of cases if things are not done about them now. And I think quite impressively, in the few weeks since this has started, something like 85% of English court hearings are now being done in this way, of all sorts, and that includes even ones at the Supreme Court. If things change, if judges become ill, if court staff become ill, which thankfully hasn't so far happened, then there may be a change. And you may find that certain types of orders become less available, but at the moment they're available. Urgency is a key factor in an English court determining whether or not an injunction should be granted. If it is not satisfied that the situation presented to it is one of irreparable harm, that if an order is not granted, the claimant cannot possibly get enough compensation from damages, then that's a key factor. And in this, another key factor is that if there's been too much delay in seeking the order, then it's difficult to justify in the court's eyes that it's actually urgent. If you wait a vague rule of thumb more than a month, you're probably too late, but often if you waited even a matter of days or weeks after you first heard, that may be too late. It's a flexible standard. And urgency and the question of irreparable harm are still just as important in this situation. Urgency, I suppose, may be relaxed in some circumstances a little bit because, for example, the goods aren't being sold as widely because people aren't in the stores buying them, or the services can't be accessed, whatever it is that you think is infringing. And so there may be some cases where the courts say, okay, you haven't moved that urgently, but I'm going to allow you to in these circumstances. On the other hand, in those circumstances, there may also not be irreparable harm. If no one is buying or accessing the infringing service at the moment because everyone's at home under lockdown, then is there really irreparable harm? Our experience so far is that although some claimants are using the current opportunity to say, well, actually, the courts may move more quickly in some ways, let's go for some injunctions. In practice, quite a few of those are being talked down because there really isn't the same urgency or the real harm that there was. Are there any specific requirements around evidence? The English court preliminary injunction practice is based upon oral arguments by lawyers, but everything is on the papers in terms of the evidence. So there'll be written witness statements that will support the application and rebut it, and those will be done exactly the same way. It may take a little longer sometimes to find your evidence in this situation and to tie witnesses down, and you may therefore get a little extension on some of the time limits, but in theory it carries on the same way. Oral hearings, as I mentioned, those are carrying on, but they are being done usually via technology, whether it's a video conferencing technology like Skype, or whether it's just conference telephone calls, and this is happening at all levels. And there are procedures set out now in the rules as to how that works, which numbers to call and things like that. An interesting point point of principle that's quite important is open justice, that most of these types of hearings are normally done in a court that anyone can come into and listen into. Some are behind closed doors because of subject matter, but usually they're open. How do you do that in this sort of environment? And the answer is that people can still join in and dial in to these conference calls and listen in. And you just have to get the details from the court's website as to how to do that. How long does it take? And does it take longer? Normally, we would say the timings haven't really changed, but as I said earlier, some of the parts of the timetable might extend a bit. So, for example, if it's something very urgent, you can get an order very, very quickly, sometimes even within 24 hours on an ex-party basis. More normally, you have hearings which the other party is at, either what's called an ex-party or notice hearing, or usually an inter-parties hearing. And what normally happens is after the initial application is made, the court sets a timetable for the other side to put its evidence in and its arguments, and then for there to be a hearing. And that normally is a period of a couple of weeks or so, sometimes a bit longer. And those sorts of timings are continuing. The court will then grant an order within the same sort of period of time. Sometimes you'll get an urgent order granted on a very short timetable. You'll get the order, but the court will say, we want to hear everybody on this very quickly. And again, the timings for those sorts of things, which is usually a matter of days, are still exactly the same, and the judges are still available to hear them. And the final point is, well, once you get your order, what do you do about serving it? Injunctions are very draconian orders, and because of that, the procedure here is that you have to serve them personally. Obviously, personal service is difficult in these situations, and so increasingly it is possible to get an order from the court to serve orders and materials by email, or if the other side consents, if you have someone who is representing them. Okay, that's it for the UK. I'll now pass on to my colleague, Marc Schuler, who will talk about France.
Thank you, Mark. Well, in France, the state of national health emergency has been declared since 16th of March. And as a consequence, pending litigation are suspended and procedural deadlines are extended. So we are in a kind of a procedural freeze whose duration is scheduled to last at least until the 24th of May. A continuity plan has been set up for dispute relating to so-called essential matters, mainly urgent matters in family, insolvency, and criminal matters. Intellectual property matters do not fall under the scope of essential matters, and therefore preliminary injunctions are not likely to be granted in France during the COVID crisis, unfortunately.
So that, I think, answers all of your questions in one go, Mark.
Yeah.
Just so we get our full money's worth from you, what do you think will happen? I mean, to address this point that we have in the UK, that you don't want a huge backlog of cases when we finally come out of this, what do you think the courts will do about that, and what should parties be doing to put themselves in the best position for when we get to that point?
Well, for sure, it is worth getting ready for the after crisis, and to this effect, we recommend gathering any relevant evidence which can be found online, and in this respect, bailiffs are available to draft evidence reports, documenting your claim through cease and desist letters. In this respect, it is useful to consider addressing more than one letter to demonstrate that you have used all means for warning purposes, collaborating with customs for intervention if relevant, and finally preparing relevant documentation to have the complaint ready to be filed as soon as possible after the crisis.
Thanks, Mark. Sebastian, over to you in Germany.
Hello, this is Sebastian Fischoeder from Wessing, Düsseldorf. Thanks, Mark. Well, our PI is likely to be granted in Germany during the COVID crisis. Well, the policy guideline is very clear in Germany. During the crisis, courts shall maintain their work in necessary fields. And in Germany, preliminary proceedings in IP matters are considered necessary. They are considered as necessary as, for example, detention matters. Well, there's, of course, a background to this. This necessity requirement coincides with the procedural requirements. Preliminary sanctions require urgency in Germany anyway. That means they may not be applied for after a fairly short period of time. So, in essence, yes, PIs are granted in IP matters. during the crisis, and courts work almost like normal. However, as court secretarial services and postal services work slower in COVID times, the speed of proceedings is slowed down too. Is showing urgency a requirement for a PI, and has the test been relaxed at all? Generally, as a general rule, in Germany, the PI applicant has to establish urgency, which is predominantly a timing factor. There is no statutory deadline for urgency. It depends on individual courts. It is one of the most passionate topics to discuss between litigators, how individual courts assess urgency under specific circumstances, and other courts do it differently. It's an endless topic to discuss, but as a rule of thumb, an applicant needs good reasons if he waits longer than 4 or 6 weeks from becoming aware of the infringement. The strictest courts are the Bavarian courts. They say there is no PI possible after 1 month after becoming aware of the infringement. So what is now going on during the corona crisis? Several judges explained to me, and we've made the experience, that courts will decide more generously on urgency if corona constraints slow down the actions which the applicant has to take. An example, normally the PI applicant has to send a cease and desist letter. He has to set a deadline, wait for the infringer's reaction, and submit this reaction with his application to the court. If all this takes longer due to corona, courts won't deny urgency for that reason. So, yes, the urgency test is relaxed. There are no special requirements on evidence during the corona crisis, but the court's more generous approach to urgency in the crisis also affects evidence. If it takes longer for the applicant to provide an affidavit or otherwise collect evidence due to corona constraints, courts are likely to excuse that delay. What about oral hearings, use of technology in oral hearings? It is important to realize, also under normal circumstances, absent of corona, German courts regularly grant ex parte preliminary injunctions in trademark and unfair competition matters. That means regularly the defendant is not heard. As yet, during the corona crisis, most German courts avoid oral hearings. It seems that this is going to relax a bit during the next weeks. But if it's not a clear-cut ex parte case, courts now may grant very short submission deadlines for the defendant to counter-argue. Such deadlines are between 24 hours and a few days. However, such written exchange takes time, as court secretarial work and postal services work slower now. So only a few courts conduct oral hearings by video conferencing, such as the Düsseldorf courts and the Hamburg courts. However, usually a video oral hearing requires all parties' consent. For obvious reasons, defendants often deny their consent. So I think not many video conferencing oral hearings have actually been taken place, although some courts are offering that possibility. In essence, as an applicant, you want to avoid further written exchange or an oral hearing. You don't want the court to recognize any necessity to ask questions or to argue. Therefore, and that's probably an important takeaway, less is more. Applicants should keep their application in terms of facts and in terms of the law as lean and crisp as possible in order to enable the court to hand down an ex parte injunction. This means, for example, restrict the application to merely the injunctive order. Better do not apply for destruction or delivery up or for the provision of sensitive information. Make sure you send a prior warning letter with pretty much the same demands as the PI application. And make sure you gave the defendant enough time to respond to your warning letter. Well, usually 7 or 10 days will be more than sufficient. So how long then does it take? Well, I think that's a famous thing about Germany is the swiftness of getting preliminary injunctions here. So once applied, judges grant ex parte preliminary injunctions within a period of between 1 day of 4 to 5 days. If there is a further written exchange, things may, of course, be slowed down, as such communication takes longer during Corona, as explained. What about the service of a preliminary injunction? Preliminary injunctions in Germany, be they ex parte or after an oral hearing, must be served to the defendant by the applicant. If the defendant is represented by an attorney, service can be effected from attorney to attorney. Otherwise, a bailiff must serve the preliminary injunction. And so far, as we know, the Corona crisis does not significantly affect the work of the bailiffs. So regularly, bailiffs serve a preliminary injunction within several days or 10 days the most. That's it from Germany.
Thanks very much, Sebastian. There's been a couple of questions which I think will be good questions for everyone to answer, which I'll do at the end. But just one quick question, actually, on your point about bailiffs. How do bailiffs actually serve it? Do they have to put it in somebody's hands or touch them with it or something? Or is there a way of doing it without, while maintaining social distancing?
They can choose. Bailiffs can choose whether they want to serve it, let's say, in person. That means they have to bring it into someone's business, or whether they want to serve the injunction by postal service. So then the job of the bailiff pretty much is to certify that he puts the preliminary injunction into the mail. So he can't be infected.
No, okay. And if it's somebody where you haven't got a physical address for them, is there any way of serving it by electronic means?
No.
Okay.
No.
That could be a challenge then.
No, you have to know where the defendant is located in order to serve the preliminary injunction and make it valid and enforceable.
Right. Okay. Thank you. Moving on to a whole range of 6 countries. Martin Prohaska.
Hello, this is Martin from Vienna. You see from our slide here, we are covering several countries with nice flags on the top. And I want to thank my partners who contributed to me in giving this overview on a very short notice now. Yeah. So first point to know that in all countries we're having here, so Austria, Hungary, Czech Republic, Slovakia, Poland, and Ukraine. Also now, you may get an PI in the COVID crisis, though there are some differences. Looking next to the urgency requirement, as we have it listened to for Germany and UK, we have no such requirement in Austria, and we have no such requirement in Poland. On the question whether we would have specific requirements on evidence, well, usually PI proceedings don't see much difference to the normal way. So we have scanned affidavits in all countries. and filing is done by electronic means. On the hearing point, we usually don't see oral examinations in preliminary proceedings. So this is the normal case as was those proceedings handled so far, and there's no change compared to the present situation. Although the courts are closed at the moment, of course. Well, the most important question when I'm asked by practitioners how fast we could be with a PI. While for Austria, it's very much depending, to say, on the workload of the court and the judge. So it's usually 3 to 4 weeks, so not as quick as in Germany. Yeah. But if you look at the Czech Republic in Prague, you have a fixed time limit of 7 days. So for speedy injunctions in CEE, please go to Prague. In Ukraine, you see it's very much depending on the region. I have learned from my partner there that if you are in the Kiev courts, then it would be, let's say, 2 weeks or something like that. But it's very much depending on where you actually have to file. On the question of serving PI, well, different to Germany, it is not done by the attorney of the plaintiff, but by the court itself, usually via electronic means, and otherwise by the just postal services. This is the same. We have the situation in Hungary. For Czech Republic and Slovakia, we have the system which is differentiating between legal entities and individuals. So when it comes to legal entities, you have specific data boxes in both countries. And what we really can see that postal services are working very well in our countries here. So this is an overview for the countries we're covering here in CEE.
Thank you, Martin. That's interesting what you say about the postal services, because I know that is patchy. So certainly talking for the UK, things have not been as smooth as normal. They may be getting back to more normal now. And I think a lot of the normal court rules are based upon assumptions about how things like the postal services work. Is it possible to get around that and somehow serve it in some other means that avoid the postal service, or was that really the only route?
Well, usually when you apply for a PI, the PI request would be served to the defendant by postal services. So this is the normal way. Yeah. And there is no difference to normal proceedings. That's as long as there is somebody there at the premises of the defendant. Yeah. This, of course, could happen in those times now.
Right, thank you. I'm beginning to sound like I'm completely obsessed with the service of these proceedings. But interesting also to hear that oral hearings don't really affect you, because in most of those jurisdictions, you don't have them anyway. And so it sounds as though actually it's business as usual in many of the jurisdictions you're covering.
Exactly, yeah.
Yeah, okay, thank you. Okay, another multi-country approach now, turning over to Marie to look at the position in both Belgium and the Netherlands. Thanks, Marie.
Thank you, Mark. Hello, everyone. This is Marie from the Brussels office. So as Mark said, I will be presenting you an overview of the situation in Belgium and the Netherlands. So RPI is likely to be granted in these countries. The answer is yes, in both countries. In Belgium, PIs are obtained either through ex parte proceedings or preliminary proceedings. During the COVID crisis, ex parte proceedings, which are introduced by petition filed with the clerk's office and are largely written proceedings, can still be filed electronically and will be handled as usual. So there is no change here. For the rest, as a matter of principle, all hearings are suspended and no new cases can be filed except in some cases, including urgent matters, which includes preliminary proceedings. So this confirms that PIs can be obtained in Belgium, more or less as usual. In the Netherlands, the matters have been divided into 3 categories: most urgent matters, urgent matters, and regular matters. Until the 7th of April, the district court would only hear extremely urgent cases. But since 7th of April, the possibilities to conduct an oral hearing through a video connection has been expanded, and the courts aim now to hear more than the most urgent cases, and also include urgent cases, which include, as in Belgium, preliminary proceedings. We did have a confirmation within our team that PIs are handled as usual in the Netherlands, since we filed for a PI in the Netherlands, and there is a hearing that has been fixed on the 13th of May. So this was a nice confirmation of the possibility to obtain a PI in the Netherlands. Regarding the urgency requirements, the situation is different in Belgium and in the Netherlands. In Belgium, urgency is a requirement to obtain a PI, and is actually an admissibility condition of PIs, and will be assessed based on all the circumstances at stake. One of the criteria that will be taken into account is the behavior of the claimant. We will look at whether the claimant took too much time to bring the action before court, because if he did take too much time, the matter could lose its urgent character. We do, however, expect that the judges during the COVID will be a bit more lenient in this regard, and will consider that it might be more difficult and more complex to bring a PI in these times. In the Netherlands, the urgency of a case has mainly an impact on the setting of the date of the oral hearing. So depending on the urgency of the case, the judge will determine whether the oral hearing can be postponed, or otherwise will decide that oral hearing will take place in a different format. I understand that this assessment will take place in the same way than before the COVID, and that for example, in the case we had in the Netherlands, an oral hearing was fixed, so no changes are expected on this point. Regarding the evidence, both in Belgium and in the Netherlands, we do not expect any specific requirements on this topic. And in Belgium, there has been some directives that have been published which impose evidence to be filed electronically or left in the mailbox of the court, whereas usually evidence are filed at the clerk's office. So this is a small difference. And for electronic filing, this happens through digital platforms, which are available for free during the COVID. In the Netherlands, there's no specific requirements. We do, however, expect that the judges will be a bit more lenient in the way evidence can be filed, and, for example, digital filing will be accepted. So now that we've covered evidence, what about the oral hearings? Here, the situation is different, again, in Belgium and the Netherlands. In Belgium, as I mentioned at the beginning, all hearings are suspended except in urgent cases, and preliminary proceedings are considered urgent. For ex parte proceedings, as I mentioned, these are written proceedings, so there are generally no oral hearings. However, for preliminary proceedings, lawyers are asked to opt for written proceedings. This is a possibility that already existed in the Belgian Judicial Code before COVID, so this is an existing possibility, but it was not often used. But lawyers are now asked to use this proceeding, which means that all the evidence and written submissions are sent to the court, who will decide on the basis of these documents without hearing the parties. In the Netherlands, the oral hearing will take either in writing, which I understand is more or less similar than in Belgium. So the plea notes are submitted to the court by email, or the oral hearing can take place through video conferencing. One interesting thing on this point is that in the Netherlands, they have ensured that oral hearings can be public. So as even if you're not involved in the case as a party, you can attend the hearing. And we actually have members of our patent team in the Netherlands that have joined a hearing yesterday. So we can confirm that this works. Now, what about the timing to obtain a PI? So first thing to know is that we do not expect any particular delays, neither in Belgium nor in the Netherlands. In Belgium, it usually takes a couple of days to obtain a PI with ex parte proceedings. Preliminary proceedings will take more time. It can take 1 to 6 months. It is usually for usual cases, trademark cases, it's 1 to 4 months. And for complex cases such as parallel import cases where you have regulatory issues involved, it can go until 6 months. In the Netherlands, though no delays are expected, and it is usually 10 weeks to obtain a PI. So last question about the service of the PI. In Belgium, any decision if to be enforced has to be served by a bailiff. So this includes for PI. In the Netherlands as well, PI has to be served by bailiff. This remains unchanged during COVID. However, in both countries, the professional body of bailiffs has given statements containing guidelines on how to serve a PI in the circumstances of the COVID in order to comply with the social distancing measures. So, for example, in the Netherlands, bailiffs have to leave the decision in the letterbox and then we'll follow up with a contact with the person who has been served. In Belgium, similar measures have been also required from bailiffs. And there's one thing which actually goes back to what Marc was saying, asking earlier about the possibility to serve digitally decisions. Since February of this year, actually, their platform has been put in place in Belgium to allow digital service. So it's really in the beginning of the platform. So it's the COVID situation is actually a good test to see how it works. I know that it is being used by bailiffs, not much yet, but I assume it will be more and more used in the coming days. So this is it for Belgium and the Netherlands.
Thanks very much, Marie, and neat segue there to a topic we'll pick up shortly, which is about what the new normal is and how things are going to change and whether that means permanently. You touched upon the question of urgency and whether the courts may relax things a bit given COVID. Yep. And I know we've had a question from the audience about that, and it sounded as though the answer from at least your perspective is the court may relax to some extent. However, it'd be interesting to hear just from the other countries whether they think that'll happen. I mean, I think there may be a bit of that in the UK, but it's all going to depend on the case. And if in fact it takes a few more days to contact people and make decisions, I think courts will understand that. But I think it's not an excuse to really add weeks and weeks to things. What do you think about it in Germany, France, and Austria? Just start Germany.
Yeah, this is Sebastian from Germany. I think German courts would approach it pretty much in the same way. Of course, they would be more generous if things just take longer due to slower processes for corona reasons. But generally, once the person or the circle of persons which decides over infringement matters or unfair competition matter has gained knowledge, or if knowledge has gained in these persons on these persons' behalf, then the urgency clock starts ticking. And if it needs more persons to know or to make that decision, this isn't an excuse for a longer timing, even under corona circumstances.
Right. Thank you. Martin?
Yeah. For Austria and for Poland, I have mentioned already that we have no urgency requirements. So you may file for a PI in the usual set of the statute of limitation you have, but don't wait too long, of course. And in the other countries covered in my slide, Hungary, Czech Republic, Poland, well, I just talked in Poland, Slovakia and Ukraine, there is no strict concept of urgency as we have it in Germany. It's more a flexible system. Of course, there still must be an actual or imminent infringement. But in contrast to Germany, there is not a set of rules that is set in stone.
Right. Thank you. Marc, do you want to cover France? Obviously, slightly different position there now anyway.
Well, for us, I would say taking into account the circumstances, it wouldn't change that much. But yeah. I think it will be useful when I was mentioning to address multiple season dislitter, as although in France the agency is not so much of a criteria as I would say it has to be manifestly infringing to justify the preliminary injunction. Still, to be in a position to demonstrate that we've taken all measure to warn the third party concerned will be helpful to convince the judge that, notwithstanding the crisis, the trademark holder has done everything in its power to alert the third-party infringer in relation to the infringement concerned. So it will be useful, I think, to use multiple cease and desist letter.
Perfect. Right. Thank you all. We're nearly at the end. We're just going to cover a couple of things. The first really is looking across the sweep of all the different countries we talked about, and I appreciate it's been a quick tour. There are, we think, a number of sort of common takeaways. It's a classic situation where it's worth knowing the position in different countries, particularly if you have a type of right where you can engage in some forum shopping is a bad word perhaps, but some analysis of where may be the best place to sue. So, for example, if you have an EUTM and you are faced with infringements in a number of countries, it may be possible to find a court which is more friendly, or in fact, in the case of France, more open, to obtain your injunction, which may be effective. So I suppose one question of those, don't think about just going down your normal routes to your normal courts, as you may have done in the past. You may want to look at different options. And as we've heard, then there's quite a range in terms of the speed, the things that are required in different countries, and how adept they are at dealing with things in this new situation. In terms of more pragmatic things, I think something which we're all, I think, thinking is that you want to make this as easy as possible for the courts. So this is not probably the time to load your application down with all sorts of orders which may be useful, such as delivery up of particular infringing items or obtaining information or anything like that. If you want an injunction, just apply for the injunction to prevent the harm carrying on. Don't overload it. There may be a time for those, but at the moment, less is definitely more. Urgency, we just talked about quite a bit, and this whole question of ongoing harm, we're in a different situation. Things are shut, people aren't shopping in the same way. So can you really say there's an ongoing harm? And I've certainly had cases where it's, there's things to do with sports seasons and the sporting events are just not carrying on. So actually the heat goes out of it for all the parties and you can all reach a new resolution before the season recommences or the next season happens. But if nothing's happening, no one's going to be harmed in the meantime. And actually that brings on to one of the points at the end of that slide about online mediation. But there may be some circumstances now where a fight in court may have been the preferred threat, at least, and possibly the preferred solution, but actually in a situation where maybe an online mediation works as well. It may be cheaper, it may enable a more pragmatic solution with the parties being encouraged to do so by a mediator. And in the London office, for example, we've got at least 2 cases now which are looking at online mediation. So it's definitely an option. And the other one is, in terms of common themes, preservation of evidence. At some point, you're going to be able to get justice with a bit of luck, even if you can't necessarily everywhere now, or it may not be the time. But it's just as important, perhaps more important, to preserve evidence, to work out exactly what was going on when, and have that material ready for when you do want to come back before the court. Looking further ahead, there's some interesting questions about it, to what extent these changes are temporary, and are we entering a new normal? And I'm sure many people on the call are finding that actually remote working is a pain in some ways, but in many ways works pretty well. And many of the things we used to do may not be necessary or may be done differently in the future. We're all used to this. Does that apply to court proceedings as well? Well, possibly it does. I think there will be more remote hearings. There's a very interesting project that was already underway called Remote Courts. It's worth having a look on the website of that because it's got a lot of updates on what's happening in different countries. And so I think you will see more of that, which hopefully will increase efficiency and hopefully reduce cost. And there's also an interesting question of transparency. Transparency of the justice system, hugely important. How do you make it happen when you've got a kind of closed environment, or potentially closed environment? And I think it's important that the courts are encouraged to make their processes open and accessible. And I know many of them are thinking that's important, and technology hopefully can play a big role in making that happen. All of a sudden, we may find that our court systems, which in many ways are quite old-fashioned, will be rushed into the 21st century, and we may find all sorts of benefits from this along the line, though I admit it's a bit of a silver lining at the moment. And finally, unless there are any questions for anyone, we just wanted to share what may be a salutary lesson from the United States on preliminary injunctions. This was a case which happened about a month ago now, and a month ago seems like complete ancient history, and it was a time when there was mass panic and no one could work out how to do anything. And it may be that actually, a month on, as we've heard from some of the speakers, things are more settled and courts have figured out how to do things. I think Belgium was a good example of that. But in this case, this is a case, and I'm sure we've all come across these, where a manufacturer of toy unicorns and elves was unhappy that someone else was copying them and went to the court in Illinois seeking an urgent order and saying it's very important that even though the coronavirus is going on, this is stopped. I'm suffering harm. This is an emergency. And what we've quoted on the slide there are really just some of the words from the judgment, which are very, very trenchant and I think are a good illustration of the risk you may face, that you may annoy the courts if you try to injunct things which really aren't worth it at this point. So he said, plaintiff recognises the community is in the midst of a coronavirus pandemic A plaintiff argues that it will suffer an irreparable injury if his court does not immediately put a stop to the infringing unicorns and the knockoff owls. The court can still hear emergency motions, but resources are stretched and time is at a premium. If there's ever a time when emergency motions can be limited to genuine emergencies, now is the time. Filings call to mind the sage words of the lady Root: about half of the practice of a decent lawyer is telling would-be clients that they're damned fools and should stop. The world is facing a real emergency, plaintiff is not, motion denied. And I think that's a great, I'm sure we'll follow that practice in our normal lives, but telling clients that maybe this isn't the time to apply for injunctions is also an important part of our job, and never more so. So with that, unless anyone else has any questions, we are finishing hopefully within time. Please feel free to send in questions afterwards. We'll all be happy to answer them. And there will be a copy of this presentation available via a link, which we will send you afterwards. And hopefully you'll find that useful or share it with your colleagues. Thank you very much.